This is the internal Secret Service memo they never wanted leaked. This is the resignation letter that just shattered the illusion of loyalty. This is the moment when Donald Trump's most trusted protectors decided they have had enough. Breaking news out of the Department of Homeland Security has just confirmed what insiders have been whispering about for weeks. The Secret Service, the elite agency responsible for protecting the president's life, is in a state of near mutiny. Tuesday afternoon, January 20th, 2026, at 3:42 p.m. Eastern Standard Time, the acting director of the United States Secret Service submitted her resignation to the Secretary of Homeland Security. Kimberly Cheetle, a 30-year veteran of the agency, cited irreconcilable differences with the president over the scope and legality of orders she has been given. We are talking about the head of presidential protection walking away. We are talking about senior agents requesting transfers out of the presidential detail. We are talking about whispered conversations in the hallways of Secret Service headquarters about whether agents can legally comply with what Trump is asking them to do. Sources inside the agency, speaking on condition of anonymity to the Washington Post and CNN, describe a crisis of confidence and morale. Agents are being asked to prevent state law enforcement from executing lawful court orders. They are being asked to physically block sheriffs from entering Trump properties. They are being asked to choose between their oath to protect the president and their oath to uphold the Constitution.
A 30-year veteran of the agency cited irreconcilable differences with the president over the scope and legality of orders she has been given. We are talking about the head of presidential protection walking away. We are talking about senior agents requesting transfers out of the presidential detail. We are talking about whispered conversations in the hallways of Secret Service headquarters about whether agents can legally comply with what Trump is asking them to do. Sources inside the agency speaking on condition of anonymity to the Washington Post and CNN describe a crisis of confidence and morale. Agents are being asked to prevent state law enforcement from executing lawful court orders. They are being asked to physically block sheriffs from entering Trump properties. They are being asked to choose between their oath to protect the president and their oath to uphold the Constitution. The American political landscape has never witnessed anything quite like this. Donald Trump, the 47th President of the United States, entered his second term carrying a distinction no other commander-in-chief has ever held. He is the first former president to be convicted of felony crimes. The journey from businessman to reality television star to president has been marked by legal controversies at every turn, but the years from 2023 to 2025 represent an unprecedented chapter in American legal and political history. During this period, Trump faced 4 separate criminal indictments totaling 88 criminal charges, alongside multiple civil lawsuits seeking hundreds of millions of dollars in penalties. Understanding this complex web of legal challenges is essential to understanding the current state of American democracy, executive power, and the rule of law. The scope of Trump's legal troubles was staggering. He faced criminal charges in 4 separate jurisdictions: a state case in New York related to hush money payments, a federal case in Florida concerning classified documents, a federal case in Washington, D.C. regarding efforts to overturn the 2020 election, and a state case in Georgia also related to election interference. Simultaneously, civil cases threatened his business empire and personal fortune, with judgments initially totaling over $500 million. Yet, by the time Trump returned to the White House in January 2025, the legal landscape had dramatically shifted. Federal cases were dismissed due to Department of Justice policy against prosecuting sitting presidents. State cases stalled or collapsed, and appellate courts began reconsidering massive civil penalties. The transformation reveals as much about the American justice system's relationship with presidential power as it does about Trump himself. The New York civil fraud case, the art of overvaluation. At the heart of Trump's civil legal troubles was a sweeping fraud case brought by New York Attorney General Letitia James in September 2022. The lawsuit alleged that Trump, his adult sons Donald Jr. and Eric, and the Trump Organization engaged in years of fraudulent practices by vastly inflating the values of properties and assets on financial statements. The allegations painted a picture of systematic deception. Trump Tower apartments valued at triple their actual size. Mar-a-Lago estate claimed to be worth as much as $739 million when assessors valued it far lower, and net worth statements that exaggerated his wealth by billions of dollars. These inflated valuations, prosecutors argued, were used to secure better terms from banks and insurance companies, giving Trump unfair advantages in the marketplace. The trial, which stretched from October 2023 to January 2024, became a spectacle of legal drama and political theater. Trump attended multiple days of proceedings, often using courthouse appearances as campaign events. He testified in his own defense, proclaiming himself an innocent man and characterizing the case as political persecution. The prosecution called 40 witnesses and presented extensive documentary evidence of discrepancies between Trump's stated values and independent appraisals. Defense attorneys argued that the financial statements came with disclaimers noting they were unaudited, that banks conducted their own due diligence, and that no lender complained of being defrauded. Indeed, all loans were repaid with interest, and banks testified they were satisfied with their business relationships with Trump. In February 2024, Judge Arthur Engoron delivered a devastating ruling. He found that Trump and his co-defendants had engaged in persistent fraud and ordered them to pay $354 million in disgorgement plus interest, a total exceeding $450 million. The judgment also banned Trump from serving as an officer or director of any New York corporation for 3 years and prohibited him from seeking loans from New York financial institutions during that period. Trump's sons faced 2-year bans and multi-million-dollar fines. Engoron's decision was scathing, noting that defendants submitted blatantly false financial data and showed a complete lack of contrition and remorse. He found their claims of innocence to border on pathological. The case seemed to represent accountability catching up with Trump's business practices. But the story didn't end there. In August 2025, after Trump had returned to the presidency, a New York appellate court threw out the massive penalty in a split decision. While 4 judges agreed Trump was liable for fraud, a majority ruled the nearly $500 million fine was excessive and violated the 8th Amendment's prohibition on excessive fines. The ruling was complex and divided. Some judges believed James had proven her case and the penalty was justified. Others felt she exceeded her authority, noting that Trump's lenders felt no grievance and could have sued him themselves if they felt wronged. One judge wrote scathingly that James' ultimate goal was political hygiene aimed at derailing Trump's political career rather than protecting the marketplace. The reversal represented a major victory for Trump, who claimed total victor on social media. However, the fraud finding itself remained intact, and the case continues through further appeals. Attorney General James vowed to appeal the penalty dismissal, and Trump remains subject to injunctive relief limiting his business activities in New York. The case illustrates a recurring theme in Trump's legal saga: initial devastating judgments followed by appellate reversals or reductions that complicate simple narratives of either total victory or complete accountability. Federal and state criminal investigations. The 4 indictments. The criminal cases against Trump represented something entirely unprecedented in American history. No former president had ever been indicted on criminal charges, much less facing prosecution in multiple jurisdictions simultaneously. The first indictment came from Manhattan District Attorney Alvin Bragg in March 2023, charging Trump with 34 felony counts of falsifying business records. These charges stemmed from $130,000 in hush money payments to adult film actress Stormy Daniels before the 2016 election, allegedly to prevent her from speaking publicly about a sexual encounter with Trump. The payments were routed through Trump's personal attorney Michael Cohen and disguised as legal fees on Trump Organization books. Trump's legal team argued he was unaware of any unlawful scheme and that Cohen, who became a cooperating witness, was unreliable. But in May 2024, after a 6-week trial featuring testimony from Cohen, Daniels, and other witnesses, a Manhattan jury convicted Trump on all 34 counts. He became the first former or sitting president ever convicted of felony crimes. However, the legal consequences proved minimal. Trump's November 2024 election victory complicated sentencing, and in January 2025, Judge Juan Merchan sentenced Trump to an unconditional discharge, meaning no jail time, no probation, no fines. The conviction remains on Trump's record, but he faces no punishment. Trump is appealing the conviction, and the case continues through the appellate process. The federal cases brought by special counsel Jack Smith were potentially more serious. In June 2023, Smith indicted Trump on 40 counts related to mishandling classified documents, alleging Trump illegally retained national defense information at his Mar-a-Lago estate and obstructed government efforts to retrieve it. Prosecutors claimed Trump showed classified materials to visitors, moved boxes to hide them from investigators, and directed employees to delete security footage. In August 2023, Smith brought a second indictment in Washington, D.C., charging Trump with conspiring to overturn the 2020 election results through knowingly false claims of voter fraud and pressure on state and federal officials to block Joe Biden's victory. These cases represented existential threats to Trump's freedom and political future, but both ultimately collapsed. In July 2024, Judge Aileen Cannon dismissed the classified documents case, ruling that Smith's appointment as special counsel was unconstitutional, a controversial decision that legal experts widely criticized. Smith appealed, but after Trump's election victory, he moved to dismiss both federal cases, citing Department of Justice policy prohibiting criminal prosecution of sitting presidents. The charges were dropped, though Smith's final report concluded there was sufficient admissible evidence to obtain and sustain a conviction in both cases. The Georgia case brought by Fulton County District Attorney Fani Willis in August 2023 charged Trump and 18 co-conspirators with attempting to overturn Biden's Georgia victory through a racketeering conspiracy. The case was dramatic and sprawling, but it became entangled in controversy when Willis' romantic relationship with a prosecutor she hired became public. In December 2024, an appellate court disqualified Willis from the case. In November 2025, Pete Scandalakis, who took over as prosecutor, dropped all charges against all defendants, citing inability to find another willing prosecutor. The case ended not with a verdict, but with prosecutorial collapse. Impact on the 2024 campaign: legal troubles as political fuel. Conventional political wisdom suggested that multiple criminal indictments would be fatal to any presidential campaign. Historically, candidates facing serious legal jeopardy have withdrawn from races or seen support evaporate. Trump defied this expectation spectacularly. Rather than sinking his candidacy, the indictments appeared to energize his base and reinforce his narrative of persecution by a corrupt establishment. Each arraignment became a campaign event. Each court appearance generated fundraising appeals. Trump convinced millions of supporters that the cases were not legitimate prosecutions but political warfare designed to prevent his return to power. The strategy proved remarkably effective. Trump dominated Republican primary polling throughout 2023 and 2024, even as he faced arrest, arraignment, and trial. His conviction in the New York hush money case, which came just months before the Republican National Convention, barely dented his support among Republican voters. Post-conviction polling showed his numbers remaining stable or even rising. The guilty verdict, rather than disqualifying him in voters' eyes, seemed to validate his claims of a rigged system. By the time of the November 2024 election, Trump had successfully transformed his legal troubles from a liability into a core campaign theme: the embattled outsider fighting corrupt institutions. The political success of this strategy had profound implications for the American justice system. It demonstrated that a major political figure could potentially be immune from legal accountability simply by maintaining sufficient popular support and winning elections. The Department of Justice's policy against prosecuting sitting presidents, a policy rooted in concerns about hampering executive function, meant that electoral victory could serve as a shield against criminal prosecution. Critics argued this creates perverse incentives and undermines the principle that no one is above the law. Supporters maintain that voters, not prosecutors, should decide who leads the country, and that Trump's victory represented the Democratic will overriding what they saw as politically motivated prosecutions. Constitutional questions about prosecuting former presidents. The Trump prosecutions forced the American legal system to grapple with questions that had never been definitively answered. Can a former president be criminally prosecuted for actions taken while in office? Does presidential immunity extend beyond the term of office? What acts qualify as official duties protected by immunity versus private conduct subject to prosecution? The Supreme Court addressed some of these questions in a landmark July 2024 ruling that reshaped executive power. In Trump v. United States, the court ruled 6-3 along ideological lines that presidents have absolute immunity from criminal prosecution for core constitutional powers, presumptive immunity for other official acts, and no immunity for unofficial acts. The decision was simultaneously sweeping and murky. It established broad protections for presidential conduct, but left crucial questions about what constitutes an official act to be determined by trial courts on a case-by-case basis. Special Counsel Smith responded by filing a superseding indictment attempting to reframe Trump's conduct as unofficial campaign-related activity rather than official presidential duties, but the case was dismissed before these arguments could be fully litigated. The immunity decision has far-reaching implications beyond Trump's cases. Future presidents will enjoy expanded protections from prosecution, potentially emboldening more aggressive or legally questionable conduct. The ruling also creates complex questions about evidence. Communications and documents from a president's term might be off-limits as evidence even in prosecutions for unofficial acts. Critics, including the 3 dissenting justices, warned the decision effectively places presidents above the law and undermines democratic accountability. Supporters argued it protects the presidency from harassment by political opponents and preserves executive independence. The debate reflects fundamental tensions between accountability and effective governance that the founders never fully resolved. What happens next? The legal landscape moving forward. As of early 2026, Trump's legal situation has stabilized dramatically from the chaos of 2023 to 2024. The criminal cases have either been dismissed or resulted in convictions without punishment. Civil judgments, while still significant, have been reduced or remain tied up in appeals. Trump now wields presidential power, which provides substantial protections and strategic advantages. The Justice Department, under his appointed Attorney General, has even begun investigating some of the prosecutors who brought cases against him, including Attorney General Letitia James in New York. A development that critics characterize as political retribution and supporters see as accountability for weaponization of the justice system. However, Trump's legal troubles are not entirely resolved. The New York fraud case continues through appeals, with the fraud finding itself still intact, even as the penalty was thrown out. His criminal conviction in the hush money case, while resulting in no punishment, remains on his record and is being appealed. Civil lawsuits from writer E. Jean Carroll, who won judgments totaling over $88 million for defamation and sexual abuse, are working through the appeals process. Multiple lawsuits from law enforcement officers injured during the January 6, 2021 Capitol riot remain active, and new legal challenges to his administration's actions are already piling up, with hundreds of cases challenging executive orders on issues ranging from birthright citizenship to tariffs to federal agency control. The ultimate legacy of Trump's legal odyssey remains to be written. Has the system proven resilient, subjecting even a president to legal scrutiny and demonstrating that no one is above the law? Or has it proven ineffective, unable to hold a popular political figure accountable when violations occur? The answer likely depends on one's political perspective and constitutional philosophy. What's undeniable is that Trump has stress-tested American legal institutions in ways never before attempted, and the system has responded with a mix of accountability, complexity, and ultimate inconclusiveness that reflects both its strengths and its limitations. For supporters, Trump's survival represents vindication, proof that politically motivated prosecutions fail when confronted with robust defense and democratic will. For critics, the outcome represents a failure of accountability, a demonstration that sufficient wealth, political power, and popular support can insulate even the most powerful from consequences. The truth, as often in American life, likely lies somewhere in the murky middle, where legal principles, political realities, and democratic pressures collide in messy and unpredictable ways that our constitutional system was designed to accommodate, if not always gracefully resolve.